Hey, it's James, Father's Rights and Resources, hashtag how I got custody. I'm in my vehicle, obviously. A lot of times I do videos in here, especially on Instagram, where I have 100 more videos than I do on YouTube. And because it's just easier to do little quickie or to go live there and to do quick videos when I'm thinking of something or inspired or come across an issue that I think I need to tell people before I forget. I talked about this issue on Instagram on a live, which I can't, it doesn't save that, so I'm doing it again separately on YouTube. But if you want to see more videos from me, go to Instagram, how I got custody, and you'll see stuff almost daily from me there. YouTube is just a little harder to upload, or a little more challenging, or it's duplicative. I have to go in and edit the videos or redo them, because I do a lot of videos where I go, I do IG live where people can ask questions. I might do a YouTube live here or super chat sometime soon here. But anyway, daycare. You never want to have a child support order that automatically takes out daycare. That's the dumbest thing in the world when it comes to the child support issues, because of how many people have gotten screwed on that. Any attorney with half a brain would not allow it, but these attorneys don't have half a brain. They're all a bunch of stupid, moronic, dumbed down, airheaded pieces of crap. Now, why would I say don't have daycare costs automatically taken out of your check or garnished or part of the collection process? The answer is obvious. Daycare might change. Your kid might go to a different daycare. Your kid might go to, or the mother might pull the kid out of daycare. This has happened many times. I've had clients, well, I know of at least one client, didn't know his kid was not in daycare for a year. Yeah, that's kind of neglectful and dumb to not know whether your kid's in daycare or not, because you should be checking up on stuff and getting records and receipts and things like that for your own good. But I can't remember what his scenario was. The guy might have worked 5-10 hour shifts all day, all week, and the mom was lying to him, and she did all the picking up and dropping off. But you would think, like, one time out of the year, you might go and pick up your kid from daycare or check in on it, see what they're teaching your kid, especially if they're trying to feminize your little son, like the schools are trying to do. So that being said, let's say you have a court order that says you pay $500 in basic child support and then a month, and then you owe $500 a month in daycare, because daycare's $1,000 and you guys split it 50-50. You should not have $1,000 automatically taken out of your check. You should not have that being automatic, because the very next month the mother could take the kid out of daycare. I have a friend who his daycare gets taken out. There's a set amount, and then also she can call up Division of Child Support and have them garnish or threaten to say, hey, you owe this much, or you haven't been paying up, or we're going to start taking this out. This friend of mine, his baby's mom, she was claiming that she's paying her parents to watch the kid, and she works from home. So, but the dad has joint decision making on daycare. That's another thing that you should have in your parenting plan. Most parenting plans will say joint decision making. Some states call it joint legal custody, which is the dumbest wording I've ever heard, because custody means you're physically handling or controlling something. There is no custody when it comes to making decisions. They should just call it decision-making authority and call it, what it is. But anyway, they say joint legal custody and joint custody or joint physical custody. Just talk about custody and talk about decision-making. So in any case, in this situation, the mother was lying and saying, that her parents were providing daycare. Well, the father had joint decision making on it, and the father didn't agree to the parents doing daycare. She said something about they're going to watch the kid or babysit the kid, and she was just giving him that information for informational purposes. And but then she turns around and tells Division of Child Support she needs a bunch more money for daycare for that. And again, she's working from home during COVID. So you want to eliminate every possible chance that somebody has to extort money from you, for lack of a better term. So you should never have a child support order that says this is the amount of daycare. It should always be a percentage. And you pay the provider directly. That way, you write a check to the daycare, and the daycare, you send a check to the daycare. They say, hey, your kid's no longer in daycare. You need to take this back. So if you didn't know what was going on, you're dealing with them directly. You'll find out whether there's a daycare or not, if you're not staying in the loop or you're not in communication with the mother or whatever. You really should have a percentage there. Like if you're like in Washington, your income ratio dictates your percentage. So if you make $6,000 a month and the mother makes $4,000 a month, your income ratio is 60-40. So you pay 60% of extraordinary health care costs and daycare. And speaking of that, you don't have an automatic amount coming out for health care. Now, if you have back child, I'm not talking about if you have back child support and you get behind. I'm talking about the automatic, what's the expense right now? So you don't know when there's going to be a surgery or medical expense or stuff that's not covered by insurance. So you just have a percentage of healthcare costs usually in a child support order. That's what daycare should be. And then if you have a parenting plan, and excuse me, I should have clarified this. The parenting plan should say joint decision making on work-related daycare. Because if you don't have that and the mother puts a kid in daycare and then you have to go and fight, then they'll say, oh, well, that kid's already in the daycare. The mother already chose it. The kid's already used to it. It's already what it is. If you have joint decision-making on work-related daycare, the person has to be working and both parents have to agree on it. The mother might find a daycare that's $1,500 a month and you can find one that's $800 a month that's just as good. So you want to have joint decision-making on it. But you never want, this is the justification. I actually heard a father's rights group told the dad, like a bunch of idiots that they are, like the father's rights movement, which is filled with a bunch of people who lost in court, don't know anything about it, are mad at the system, and then they create a father's rights movement chapter in a state, and then you got, I don't know, it's like the Looney Tunes running the insane asylum or whatever. It's like the people who lost in court, who don't know how to win in court, are teaching other guys their strategies in court, which makes no sense. The father's rights movement is a total sham. I wouldn't call it a hustle and a con because I don't think they really make any money. Maybe get some donations, but they spend too much time on wasteful things like 50-50 custody laws when the judges will just ignore those laws, or there's always an exception. I have a whole video on why 50-50 laws won't work. But I saw a father's rights movement group, I talked to a dad who said this father's rights advocate told him, just have the daycare taken out of your check. It's just easier. Yeah, it's easier and it's more convenient to do a bill pay type of thing if you know what your bill is. But you don't have $100 taken out of your check automatically or out of your bank account by Macy's every month, because at some point the balance turns into zero and you shouldn't be paying anymore. You know, you don't have an automatic set amount forever. When you have a court order, that is the court order forever until the kids are 18, of course. But pretty much that's the permanent court order until otherwise ordered. So why would you sign an order say you have to pay this amount for a service that terminates, like daycare? Kids don't go to daycare for life. That eventually ends and then they change. Why would you have a set amount for something that goes up and down? Now, the basic amount of child support is a set amount based on your income, based on the laws. Child support's unconstitutional. It's a total scam. The only reason that it should even exist is when an absent parent abandons the child, like my baby's mom did for years. But things like expenses that change should not be locked into a court order. But stupid, jackass, dumbed down, moronic, airheaded attorneys will say, oh yeah, just sign off on that. That's great. You need to make sure that if you decide you want an attorney, I never recommend anybody ever have an attorney unless they're having them do a deposition. But if you want to go ahead and roll the dice with an attorney and screw yourself, if you have an attorney, light a fire under their tail and make sure they're advocating for you. And don't let them sign off on an order that says you automatically get this amount of money taken out of your check for daycare. It's pretty obvious why that shouldn't happen. But you know what happens is these stupid morons that have a law degree, that grew up behind a white picket fence, living in yuppie world, and are married and have never been divorced, those people can't empathize with your scenario. They're too stupid to catch on. Like their last client who got royally screwed on daycare, they don't say, oh, that's a bad idea. Let me stop doing that with the rest of my clients. They don't care because the lawyers are just making money and moving on to the next case and making as much money as possible for as little effort as possible. So they don't pick up on when something is screwy or when something causes a problem or when something causes somebody to extort money from you. Now in Washington State, there's a law that says you can get reimbursed for extraordinary daycare costs that are not actually incurred. Well, why would they have a law that you get paid back for daycare that's not incurred? How is it even possible that you can get money taken from you for an expense that doesn't exist? Obviously, it's happened where at some point somebody had to pass a law for that. Yet these stupid attorneys can't pick up on that fact and that potential danger. And so the problem is instead of you having to clean up after they've taken daycare for 3 or 4 months and the kid's out of daycare, or the daycare costs went down or something like that, and they're still taking the full amount, instead of you having to put forth effort and having to go clean it up or fix it or undo it, why not just have it? You pay the daycare directly, and if there's a problem, you realize it right away and you fix it right away because the daycare tells you, oh, you overpaid us, or your kids aren't in daycare anymore. What are you doing? Here's your money back. Then you don't have to go jump through a bunch of hoops with division of child support or go to court and modify or motion the court for a judgment. And then even when you overpay, you don't get that money back. It's just a credit toward future child support. So it's almost like they cater to their system because the entire system gets money for child support. Every dollar of child support that's ordered, not every that's collected, but every time, like there's a new order of child support this month for you or for somebody else, $1,000. Most states get a matching $1,000 bonus from the federal government. And then at the end of the year, DSHS in that state or Department of, what's DSHS in Washington? Division of Health and Human Services, DHHS in some places, something like that. That's the general umbrella the child support services are under. A whole corrupt entity that shouldn't even exist. Welfare, social services, all that other stuff. All that stuff shouldn't even exist for the most part. It's government governing money going to families and to people and all this stuff that churches and entrepreneurs or advocates should be doing individually of their own free will and free money and free time. But the bonus money, like every time there's a new order of child support, the government gets matching dollars, just like the prosecutors get matching dollars every time they prosecute a domestic violence case. If a prosecutor spends $10,000 taking somebody to trial on domestic violence, if they get a conviction, the federal government under Joe Biden's Violence Against Women Act will get $10,000. And it's the Violence Against Women Act to protect women and children, even though women commit 60% of child abuse. And some statistics show women commit at least 50% of domestic violence, if not up to 70%. And that's just the reported stuff. So the government gives out bonus federal dollars for one gender to protect one gender. That's why prosecutors never go after women perpetrators of domestic violence, because they get money when the women are the victims. So the point is, on the child support, they get a bonus dollar for every dollar child support they order. That's why they usually want the mothers having custody, because the father's usually the bigger breadwinner. But there's a culture, just an anti-father culture, period. And then also, like in Washington, they charge $25 a year for their services of collecting the child support. And, it's not about the child. If it was about the child, they would make sure that the custodial parent used their money and paid their obligation to the kid too. Because when you have a child support order, in each column of the child support worksheets or the setup paperwork for the child support order, it says the father earns this, the mother earns this, the father's obligation to the child is this, and the mother's this. Let's say it's $600, $400 or something like that. The child's worth $1,000, the father pays $600, the mother pays $400. They both have an obligation of child support to the child. They define that first, and then they decide, who's got custody? The mother's got custody, so the $600 from the dad goes over here. But they'll only arrest or put that dad in jail or do contempt on that dad for that transfer payment. Both of them are supposed to give their obligation to the child. Why do they only enforce and have the prosecutor go after the transfer payment from that parent? They're not making sure that money even trickles down to the kid. They're just trusting that money gets transferred over there and that money's spent on the kid. But they never make sure the custodial parent is paying their obligation to the kid. Why don't we care about the custodial parent's obligation to the kid? Because all this is about is them making that bonus money, and then them doing the collection part where they get the transfer payment. They only care about the transfer payment because they do collection services, which they charge a fee for. Whole thing's a total scam. They don't care about the kids. It's not about the kids. Or else they'd make sure kids were taken care of by both parents. They only care about the non-custodial parent. It's discriminatory. So, that being said, so anybody ever talk smack about child support, or does he pay child support, or make sure that they pay child support and look out for the kid? There's nothing that looks out for and makes sure that the kid is getting money and getting taken care of. We know countless stories of a custodial mother sending a kid to a dad and says, hey, he needs new clothes, he needs a haircut, he needs this, he needs that. All the stuff that child support is for. You already spent that child support at the salon or get your nails done or on, Match.com, where you're looking for your new boyfriend who has a criminal record that you're going to allow into your kid's life even though you're pushing the dad out. So the daycare, never let the court order say transfer this amount in daycare. You have the basic amount, let's say $500 in child support. Daycare, the father shall pay 60% of all daycare costs directly to the provider. And then in your parenting plan or your divorce decree or wherever it says it in your state, have it say you have joint decision making on healthcare decisions, school decisions, religious upbringing, gender identification, because you don't want a case like in Texas where that one mom is forcing a boy to become a girl against the dad's will. He won in the Court of Appeals in Texas, and the Supreme Court he lost because this psychotic, evil, man-hating witch hates men so much that she wants to turn her boy into a girl. Evil child abuser. So, and then you also want extracurricular activities on the decision making. You might not want your daughter playing football and your son being in ballet or something like that, or in a group that has some kind of indoctrination you don't like as a parent. Extracurricular, daycare, work-related daycare. You also might want to have like computer, cell phone, electronic usage, driver's license, military enrollment or enlistment, and dating. Some people have that, body piercings and tattoos. Things that become a conflict between parents. You want to cover all that so the other person doesn't have if you don't have that specifically in there, the custodial parent might get away with putting your kid in all kinds of stuff you don't want them in. And you're an equal parent. Even though you don't have as much time with the kid, you're an equal parent. You have equal access to medical records and school records. Even though the school and the doctors will defy you and fight you on it, or say, well, the mother didn't sign you up as a person. The mother doesn't have any say-so. I'm an equal parent under the law, you stupid jackass. Your interpretation of the law is that you think I'm a second-class parent. So you're discriminating against me and violating my constitutional right to access to my kid and the liberties that I have in raising my kid and how I raise my kid. You're running interference, and I'm going to sue the school district, and I'm going to report you to the school superintendent, sue the school district for millions of dollars in federal court for violating my constitutional rights. That's how I talk to those people. But on a parenting plan or decree that has decision-making, you want school decisions, medical decisions, extracurricular activities. A lot of times on the religious upbringing, let's say, each parent can bring their kid to their own religious activities on their own time. Sometimes they make that a joint decision in case it's a big issue. Military enlistment, body piercing tattoos, extracurricular activities, I think I said that, work-related daycare, dating, gender identity issues, or transitioning and stuff. You definitely want that on there nowadays. That's a new one. And then anything else that could be controversial, extracurricular activities, clubs and sports. And when you say daycare, you should also say camps. Daycare / summer school break camps or whatever. Now that you got the boys club settling on almost $1 billion for all the boys they molested and raped, you may want some joint decision making on clubs and camps and activities, and not get your kids involved and stuff like that. So don't ever, if you want to protect your money, don't ever sign an order or allow an order to write and say they automatically take an amount out for daycare or anything extra. You always say or even sports or activities or lessons. Oh, on extracurricular activities, I would say extracurricular activities, sports, clubs, lessons. Just to make, you can never overstate or overword something, because there's always confusion or controversy. The more you anally overstate something 7 different ways or with different wording, the more clear it's going to be, so there's never any confusion, there's never any controversy. So write down and state everything that you can on decision making that you think we need to have joint decision making on, and I don't want her or the other parent solely deciding everything. And especially don't let it be a certain amount. You have your percentage, and extracurricular activities, sports, select soccer, select basketball, daycare, camps. The father pays this percentage of these things directly to the provider. Have that language in there.